Hello students, welcome to Abhi Law, where law is simplified. This is your professor Dr. Ambarish R. Patnigiri, and we have started the introduction of the Indian Evidence Act 1872. Now, in the last video lecture, we have talked about the background of the act. Today, in this introduction video lecture number 2, we are going to start and talk about the nature of Evidence Act. आइए हम एविडेंस एक्ट के नेचर को देखते हैं. नियरली देयर आर 5 पॉइंट्स विच कैन एक्सप्लेन द नेचर ऑफ दिस एक्ट. द फर्स्ट पॉइंट इज एविडेंस एक्ट इज एन एडजेक्टिव लॉ. द लॉ basically can be divided into two categories: substantive law and adjective laws. Substantive laws are those laws that defines the rights and the duties. Adjective laws are those laws which are concerned with the method of presenting the cases to the court, proving the fact of the case, or generally enforcing the rights and duties provided under the substantive law. This is the first point. Second point is Evidence Act plays adjective role to procedural laws too. In this, we should understand it plays an adjective role both to civil and criminal procedure law. We know, हमको पता है कि सीपीसी हो या सीआरपीसी हो, दोनों एक्ट के लिए इंडियन एविडेंस एक्ट काम करता है एज एन एडजेक्टिव लॉ. नाउ देयर आर सर्टेन सेक्शंस व्हिच आर ओनली एप्लीकेबल टू सिविल कोड, सिविल प्रोसीजर कोड. दैट इज सेक्शन 23, एडमिशन इन सिविल केसेस व्हेन रेलेवेंट. सेक्शन 52 and 55, कैरेक्टर ऑफ पार्टीज इन सिविल केसेस. सेक्शन 115 to 117, एस्टॉपल. ये जो 3 सेक्शन हैं ये सिविल प्रोसीजर कोड के लिए ही लागू होते हैं, क्रिमिनल प्रोसीजर कोड के लिए लागू नहीं होते. और जो मैं अभी सेक्शन बता रहा हूं ये सिर्फ क्रिमिनल प्रोसीजर कोड को लागू होते हैं. वो है सेक्शन 24 to 30 सेक्शंस रिलेटेड टू कन्फेशंस. फिर सेक्शन 53 and 54 कैरेक्टर ऑफ द एक्यूज. उसके बाद सेक्शन 122 कम्युनिकेशन ड्यूरिंग मैरिज. सेक्शन 133 विटनेस बाय अकम्प्लिस. दीज आर द सेक्शन विच आर ओनली एप्लीकेबल टू द कोड ऑफ क्रिमिनल प्रोसीजर, and all the other sections which are there, which we have not spoken about, are applicable to both to civil code procedure as well as criminal procedure code. We will go to the next point, that is Evidence Act fills the gap of procedural law. Basically, it is the part of procedural law. Wherever there is a gap in procedural law, this Evidence Act 1872 fills that gap. How the pleading can be framed, how investigation can be conducted, these are basically the procedural law, and how evidence can be collected, these are the procedural law. This is been spoken in the Code of Criminal Procedure. Now we are going to look at law of evidence. Now law of evidence does what? Basically it tells you what is the proof, what are the standard proof which can be brought before the court, the facts which needs to be proved or need not be proved. Which are these facts? Evidence Act brings those things before the court. Value to be given to each term of evidence. This is what is the law of evidence. आइए हम चौथे पॉइंट को देखते हैं. एविडेंस एक्ट इज ए लेक्स फोरी. लेक्स फोरी का मतलब क्या है? लेक्स फोरी इज ए लैटिन वर्ड विच इज द लॉ ऑफ द कोर्ट, द लॉ ऑफ द कंट्री इन विच एन एक्शन इज ब्रॉट. वी नो ours and we implement it. In India, the law is Indian Evidence Act 1872. We can't go and take the law of Australia and talk about the Australian law of evidence. This law cannot be spoken or used in the court. So what is lex fori? Lex fori is nothing but the act which is there locally available shall prevail in the court. Now section 5 now we will come to point number 5. Evidence Act is not an exhaustive act. Exhaustive act means what? It has not covered everything. There may be certain point which may be not been covered by the Indian Evidence Act, and since this it is 1872 act, very old act, it is based on English law of evidence. Hence, because it is not exhaustive, the anything which is not involved or not included, English law of evidence can be taken into consideration and it can be used in certain places and certain areas. The court may look at the relevant common law for interpretation as long as it is not inconsistent with the Act. These basically 5 points talk about the nature of Evidence Act. Now we will go to features of law of evidence. In the features of law of evidence, remember there are 10 features which you and I should know. The first feature of the Evidence Act is the base of Evidence Act is English common law and changes made to align to Indian requirement. Sir James Stephen prepared the bill and was present and presented the bill in British Parliament. Remember, this was based on English common law, but amendments were done in such a way that it can be aligned in Indian requirement. Second feature of this Evidence Act is this is procedural law which covers who are competent witness, on what aspect witness can speak, genuineness of a document, burden of proof, etc. The third point which I would like to bring in this feature is the Act is not exhaustive. Not exhaustive means it speaks about general provision and separate procedure of evidence can be made based on subject matter requirements. That means it is not exhaustive means everything is not inclusive in this Act. There are certain things which may be not be included. Fourth point, discretion of the court. In certain provision in this Act, the court has power to accept or reject the evidences. However, the same is limited, means the court has a discretionary power. Now, point number 5, the Act allows both oral and documentary evidence. Point number 6, the Act gives importance only to direct or circumstantial evidences and there is no place of hearsay evidence. Hearsay evidence has no place in Indian Evidence Act, but there are certain exceptions which we will discuss in detail when we go and read each and every section. Now, point number 7, the Act provides protection and privileges to witnesses, including non-incrimination of self. 8th point, the very object of Evidence Act is to find the truth. This is the object of the Act. 9th point, Evidence Act is lex fori. Lex fori we have already discussed, means the law of the land. This Act is applicable to India and no other Act can be applicable in India when we are using as far as evidence is concerned. Now last point, 10, Evidence Act is applicable to both civil and criminal cases. Now before this I explained to you there are certain sections which are only applicable for civil procedure code or civil cases and there are certain sections which are only applicable to the code of criminal procedure or criminal cases. All these other sections which I have not spoken about are applicable to both the codes. With this I have completed the nature and the feature of Evidence Act. If you have liked my video, please share with others, subscribe the channel, don't forget to press the bell icon. Your subscription is our motivation. If you have any valuable comments, please send your valuable comments at abhilawcomments@gmail.com. Thank you.